Okay, so the next case is Pate v. Threlkel. And in Pate, what I did, I put a little blurb under each case that sort of summarizes what to take away from that case. So with the Pate v. Threlkel, you had a patient, 1987, Mary Ann New, is treated for medullary carcinoma of the thyroid. Have you studied that yet? Medullary carcinoma of the thyroid. It's one of the MEN syndromes, or multiple endocrine adenomatosis, multiple endocrine neoplasia syndromes. It can occur sporadically or in a familial form, and it's transmitted. The one that's familial is transmitted in autosomal dominant fashion. So, in 1990, Heidi Pate, who is Mary Ann New's adult daughter, is diagnosed with medullary thyroid carcinoma. So she filed suit against the doctors who took care of her mom for the disease. And she says that they knew or should have known that their mom had a disease that was potentially genetic, and that they should have warned the family about the possibility, and that if they had warned the family, they all would have gotten checked for it, and she would have been diagnosed at an earlier stage when it was still curable. Probably by the time she was diagnosed, it was no longer curable. So the trial court dismisses the complaint, saying that Mrs. Pate is not a patient of the defendant physician. Again, no duty of specific beneficence, right? The no duty rule is going to control. She did not fit with any of the exceptions to the requirement. It goes to the higher court. The higher court says trial court's right. We're going to support their decision. It goes all the way up to the Florida Supreme Court. And the question for the Florida Supreme Court was: does a physician owe a duty of care to the children of a patient to warn the patient of the genetically transferable nature of the condition for which the patient is treating the patient? And the court said yes. We conclude that when the prevailing standard of care creates a duty that is obviously for the benefit of certain identified third parties, and the physician knows of the existence of those third parties, then the physician's duty runs to those third parties. And the court said, the court went on, and although it wasn't asked to say this, it said it anyway. It said, it says, if there is a duty to warn, to whom must the physician convey the warning? Our holding should not be read to require the physician to warn the patient's children of the disease. In most instances, the physician is prohibited from disclosing, making such disclosure. So they basically said that it could be that the physician could discharge his duty by telling the patient. If you tell the patient, the Florida Supreme Court said, that you have a genetically transmissible disease, it's up to the patient then to tell the third party, so that the doctor has discharged his or her duty by telling the patient.
With the emphasis now on like education and EMR, pretty much every time you walk out, it seems like, if you get a cold, you get 5-page printout on what a cold is. Does that kind of make all these archaic now, because you get diagnosed and you'll end up with a packet to read about what it is, everything, kind of everything?
Not necessarily. No, not necessarily. And the reason is that if that were true, then whenever we put somebody on a drug, right, we would just give them the handout, the printout from the PDR, and say, here, read that. Okay? But that's not going to work, because some jury somewhere is going to say that's not reasonable. You can't expect patients to read that whole thing. It wasn't meant for patients, it was meant for doctors. You know what I'm saying? So does it help to give them informational stuff? Yeah, but it depends on what the information says, and it depends on how focused it is in terms of saying it. So if this is very deep in the, if you give them basically here's everything we know about medullary carcinoma of the thyroid, but you don't mention the salient fact that, hey, you might be at risk. In the SAFER case, basically, the facts were very similar. Instead of medullary carcinoma of the thyroid, the case involved polyposis, multiple polyposis of the colon. So what happened in that case was the plaintiff's father's name was Mr. Batkin, is a patient of Dr. Pack. Dr. Pack, in the 1950s and 60s. In 56, he operates on Mr. Batkin and performs a total colectomy and ileosigmoidectomy for multiple polyposis of the colon. So these are patients who develop innumerable polyps in the colon, and the likelihood of developing colon cancer is 100%, so they all treated with the resection of the bowel. Discharge summary noted that the pathological exam had revealed the existence of adenocarcinoma and diffuse intestinal polyposis from one end of the colon to the other. Dr. Pack performs further surgery on him in 61 and 63, and ultimately he ends up dying of carcinoma of the colon, metastatic to the liver, in 1964 at the age of 45. His daughter's 10 years old at the time. 20-something years later, at the age of 36, the daughter is diagnosed with metastatic colon cancer and multiple polyposis. She finds out that she gets her dad's records, finds out that he had this condition, and she sues the estate of the doctor and says, he should have told me, he should have told my dad that my dad had a genetic condition. If he had told him, then I would have been getting surveilled, and I would have been diagnosed at before my disease became metastatic. Goes to court. The trial court says no, that they dismiss the case. The appellate court disagrees and overrules the trial court, and ultimately goes all the way up. It doesn't go to the Supreme Court, I guess, or does it? Let me see. Appellate court disagreed. Okay, as the Florida Supreme Court had done in Pate v. Truckle, the New Jersey Appeals Court reversed the trial court dismissal of the plaintiff's complaint and remanded the case for resolution of certain factual questions. Unlike the approach of Florida in Pate v. Truckle, though, the New Jersey court declined to hold that in all circumstances the duty to warn will be satisfied by informing the patient, leaving open the possibility that such a warning might, in some cases, have to be given directly to the children of the patient. So these are very similar cases. They both involve genetically transmissible diseases, and the courts decide them essentially the same way. The only difference between SAFER v. Pack and Pate v. Truckle is how the physician can discharge the duty. In one case, in the Pate v. Truckle, the Florida case, the court said you can discharge the duty by telling the patient. Whereas in SAFER v. Pack, the New Jersey court said, not so fast, you have a duty to protect those third people, and how you discharge that duty is going to depend on the facts of the case. So who likes the Florida approach, and who likes the New Jersey approach? Okay, so who likes the Florida approach? Tell the patient. Okay, who likes the New Jersey approach? Flexible, depends. Huh?
Isn't this one you essentially have to tell the family?
This one says, well, it doesn't say you have to do it. It says you owe them a duty. You might be able to discharge the duty by telling the patient, but you might not. They leave it open. Florida says if you tell the patient, you've done what you have to do. New Jersey says you owe the third parties a duty. We're not going to tell you what you have to do to fulfill that duty, to meet that obligation. It might be that telling the patient is enough. It might not be. So, who said they prefer New Jersey's approach? Can everybody vote this time? Who says Florida? Vote for one or the other. Who says New Jersey? Still, some people didn't vote. Okay, so the people who said New Jersey, why do you prefer New Jersey's approach? Yeah.
I feel like it gives you more leeway to decide how you want to. You're probably less liable this way too. I mean, if somehow they came back to you, there's not like a specific way that you have to do something. Instead, it's up to you on how you do it. And as long as you do something, you should be all right.
Well, what could you do? What could you do that's easier than telling the patient? You said it's more flexible, so what could you do that's easier than telling the patient? Because Florida says tell the patient and you're off the hook. What could you do in Jersey that's easier than telling the patient?
Put it in the medical record.
For who to say?
I mean, the patient ultimately has access to the records.
Well,
That's for it.
but how many of us look at our own medical records?
That doesn't matter.
You think it would matter? I don't know. Why else would you prefer the New Jersey approach?
What if your patient doesn't like they don't get along with their children, and they say, hey, tough, they're gonna get it, I don't talk to them.
Yeah, who cares, right? That's the problem, and I think that's what the New Jersey court is concerned about, is, the Florida case makes sense in the ideal world with the ideal family, but what about in the real world with families that are dysfunctional and maybe broken families where maybe they've lost connection with, they've lost touch with the rest of their family. So perhaps the Florida, maybe the New Jersey approach is a little bit more real world.
How are you supposed to know that a family is dysfunctional though? So how are you supposed to know that your patient has so many issues that if you tell them in good faith that hopefully they'll tell? Like how
Well, that's a good question.
Yeah.
Suppose you tell the patient. So what would I do?
Yeah.
Is assuming that those other people were not my patients. Let's say it was just I'm the doctor for the father, and he's got a condition that's transmissible. So then what I would do is maybe I would say something like, let's say I'm in New Jersey. So then maybe I would say something like, listen, you have this condition that's genetically transmissible. You need to inform your children that they need to start screening at such and such an age for this condition. Okay, and if I have no reason to disbelieve him, then that might be good enough. And I might even, like if I was really risk averse, I might follow up at the next visit and say, did you have that discussion with your children? Yes, I did. Yes, he did. And who are they going to see for that? They're going to see Dr. So-and-so. Okay, and I'll put that in no. And then most people, I think, would say that, if he went to court later on, they would say, well, that was a reasonable attempt to protect those third parties. You still could lose, but you've done everything that you could. And the argument in that case for breaching confidentiality is going over the patient's head is kind of weak. If you're really worried, you could even ask them. I'll tell you what. Why don't you have the family come in instead of you telling them? I'll tell them. This way, they're probably going to have a lot of questions. I'm in a position to answer them better than you. So why don't you let me break the news with you here? You could do that.
What if it sounded like in the first case, the child was only 10 years old. So now, you warning the children is you're telling a 10-year-old with or without the parent's consent. So now and then is the 10-year-old even gonna understand? So are you responsible for when that child turns 18 to make sure that you tell them,
Well,
hey,
remember,
your dad had cancer?
New Jersey didn't say you had to tell the kid. New Jersey said you owed a duty to the kid. And how you discharged it depends on the facts of the situation. So let's say that the father was estranged from the daughter. Let's say there's a divorce, the father doesn't live with them, they don't talk anymore. It might be that you need to disclose that information to the child's guardian. Let's say it's the ex-wife. Okay, so it might be that you need to disclose that information. Now, these are not simple questions, and in a situation like that, you'd have to decide what's the right thing to do ethically, but also when you want to protect yourself, and remember that you also have to obey the law. That's one of the mandates of the moral rules. So you'd probably find out from an attorney, like, you know, what are my options here in terms, legally, what are my options legally? And, cause I'm thinking about warning, you know, if you can avoid the confrontation, you know, if you could, even if the guy's estranged, you could still say, listen, I need to let them know. I have a legal duty to let them know. I just assume that you'd be involved. Okay, why don't we have a conference call? You know? So there's probably ways to do it that avoid, you know. Other questions?
I think it's crossing the line with paternalism. So we talked about that you have a duty to parents to tell about the daughter if she's pregnant and do that in Ferguson. And I think that you have a duty to your patient, and then it's their duty from there on out. That person's duty. That's like the HIV. You tell your patient they're HIV, and now it's his. It should be. You can tell the health department, but it should be his duty, and that's why people can get sued for that, because they can go back and trace the phylogeny of the virus changing in certain people. They can trace that back to somebody.
Yeah, well, nobody's disagreeing, nobody's arguing that you owe the patient a duty, but what the statement that you just made, that you owe the patient a duty, what you're implying is that you owe the patient a duty and you don't owe a duty to anybody else.
I'm saying that he as the parent or whatever, if he's gonna sue an estate, you know, if he hates them and he's a millionaire or whatever, she should sue his estate. So this SOB should have told me, you know, and not gonna done whatever. You're not gonna have testing or whatever, putting on. I just feel like they're reaching, sticking on they're reaching for the next pocket, and the next pocket.
Well, but
is the doctor.
again, if you think about, for example, the Florida case, the father couldn't tell because he didn't know. You know what I'm saying? So you couldn't sue the father, right? Because he didn't know.
He didn't know.
The doctor didn't say
Okay.
it's genetic. And so had he told the father that this is a genetic disease and you're gonna have to look out for your children to make sure that they get screened, then that would have been a different story.
That's one.
Now that could still happen in Jersey, all right, but in Florida says you gotta tell the patient, and you discharge the duty by telling the patient.
That's why I like Florida rule. You don't get sued every day for.
Well, Florida's relatively, if you're a provider, you would think you would like Florida better, right? Because it's straightforward. Tell the patient you're off the hook. You're off the legal hook, right? You're not necessarily off the moral hook, right?
You can still get sued?
What?
Is that what you're saying?
Well, no, maybe you couldn't get sued, but what if you knew? What if you strongly suspected that he wasn't gonna tell you? Let's do the next case.
So if you strongly suspect, and if you're an upstanding moral person, then you can go past the legal duty. That's just the bare minimum to meet the legal requirement. That doesn't mean it says you have to stop at informing the patient. It just means legally, that's the minimum that you have to do. That's why I like the Florida ruling, because if you want to do more, if you suspect that there's a dysfunctional family or it's not being communicated, you can try and do something more to get the information out there. But you're not going to get sued if you don't know that it's a dysfunctional.
Well, that's one way of looking at it, but the other way of looking at it is that you could say that New Jersey is basically setting up a situation where your legal duty and your ethical duty are the same. And that, you know, it may be that you need to go beyond just telling the patient, whereas Florida is saying your legal duty is tell the patient. Well, maybe your moral duty involves telling the patient, but telling somebody else too. So they've set up maybe the situation that they've set up sets up a bad law, you know, where you could fulfill your legal duty without fulfilling your ethical duty, your moral duty. Yeah.
In his example, if you're in Florida and you tell the family but not the kids, or I'm sorry, if you tell the patient, you think the patient won't tell the kids, so you tell the kids, and you're going to your moral duty, are you then breaking the confidentiality law by telling the kids about the father's history?
Well, that's going to be a question for the court about whether that breach of confidentiality was justified or not, whether it was appropriate. So they'll have to take all of that stuff they'll have to take a lot of facts into consideration. It doesn't say, you know, one way to look at the Page v. Throttle case, it doesn't say that you may not tell anybody else. it says you can discharge your duty by telling the patient. So if you tell the patient and it becomes clear that he's not going to tell them, he's not going to share that information, then the next question is, okay, what do I have to do now? Now, again, legally, it might not be that you have to do anything else. It might not be. But it might be that you do have to do something else. Again, it says that you can discharge your duty by telling the patient. It doesn't say you're not allowed to tell them. That's not the way you should read Pate Drug. Okay? All right. Let's talk about a case of a 49-year-old man named Richard who has been married for 24 years. He and his spouse have 3 adult children and 1 unexpected child who is 8 years old. Recently, the relationship between his wife, Deborah, and Richard has become strained. You take care of both of them in your general medical clinic in Naples. I'm going to post this for you so you don't have to take notes, okay? I'll post it for you. Richard has hypertension and Deborah has a borderline case of type 2 diabetes mellitus. Richard comes into your office 6 weeks earlier than his next regularly scheduled appointment, requesting a checkup. He has no particular complaints. He tells you that a couple of weeks ago he had some nonspecific flu-like symptoms, but that these have resolved. When you ask why he didn't come in then, he shrugs his shoulders. He says, I don't know, but I'm here now and I want a complete checkup to make sure nothing's wrong with me. Sensing that he's worried about something that he's not telling you, you tell him that to do a complete checkup, you need to start with a complete history. You ask him if there's anything new has occurred since his last visit, and you learn that on a recent business trip to Las Vegas, he had several sexual encounters with prostitutes, and that he's now worried that he might have venereal disease. He denies any penile lesions, urethral discharge, or swollen inguinal lymph nodes. He insists that he be checked anyway. When you ask him what specifically he wants to be checked for, he admits that he can't get the thought of HIV out of his mind. When you take a more detailed sexual history, you learn that Richard used a condom in his Las Vegas encounters, but that he is nonetheless worried about HIV. You also learn that since returning from Vegas, he has had unprotected sex with Deborah. You tried to reassure Richard that because he used a condom, he has reduced his risk of contracting HIV in Las Vegas. You conduct a physical exam and tell him that the exam is completely normal. You suggest ordering some basic lab tests to screen for problems. You also suggest that to put his mind at ease, he should consider getting an HIV test. After signing a consent form, he is tested. Anybody have any concerns at this point in time? Yeah, I mean, one of the things that we alluded to before was a couple of things you should be thinking about. First of all, whenever you ask somebody to submit to a diagnostic procedure or a therapeutic procedure, anything that's going to potentially impact them, you have to make sure that you go through an informed consent process. Now, it says that he signed a consent form, but we don't know what the form said, and we don't know if there was any discussion that took place above and beyond the form. So that's one thing. And the other thing, remember, we said that certain diseases, and HIV is one of them, enjoys what's called super confidentiality protections. And so the protection of that information is over and above other information. So, you know, what implications are raised by the fact that we've now we're going to test them? Okay, so that stuff we'll have to come back and revisit. Anyway, a week later he comes back to give him the results of his HIV test. The result is positive. Richard's worst fears are confirmed. During the visit, you mentioned to Richard that he needs to tell Deborah so that she too can seek testing and counseling. Richard seems alarmed at this and says he's not going to tell her. He asks you not to tell her either. So the question that you have to deal with now is, how should you handle the situation should you breach confidentiality? Let's take a step back. Could we have avoided this situation? Could have avoided it by doing what? Huh?
Not suggesting the test.
Well, okay, so if you told him that, hey, by the way, if this test comes back positive, okay, if you tell him what the situation is, that there may be a legal duty to warn, then he can make an informed decision about whether he wants to submit the testing or not. Now, some people might say, yeah, go ahead.
Sorry, this is a little off from what you were saying right now, but could you, since they're both your patients, what's to say that the wife couldn't have given the HIV to him if they had unprotected sex, but he had protected sex with the prostitutes? Well,
that's a good thought, and that's actually, we do want you to think about the possibility that Richard, you should be thinking about that as a clinician, that he didn't get it in Las Vegas, that maybe he got it from her. That's a possibility. Is there anything in the facts, besides the fact that he used condoms in Las Vegas, is there anything else in the facts that suggests that maybe that's the case? Were you going to raise your hand?
No.
Oh, okay. Yeah.
Actually, he's coming to see you 6 weeks before he was scheduled to.
How does that have anything to do with it?
I mean, if he's coming 6 weeks before his schedule, then there's no issue. Why would he wait another month and a half unless he's concerned about something?
Well, he's concerned. He's concerned, but the question that the point she's making is that maybe he didn't get it in Las Vegas. Maybe he got it from Deborah. Okay, so there's a strained relationship, right? So that raises the possibility of infidelity, of marital infidelity. What else?
6 weeks prior to him going to Vegas?
What? No, he's there 6 weeks early. He came after Vegas.
Well,
Yeah.
HIV can be dormant and take a while to present, so if you
Right.
have any symptoms right after Vegas, they might not.
I think it was, we don't know, does it say when he went to Vegas? He says on a recent trip.
Yeah,
So depending on what the duration was between, it's gonna take at least a couple of weeks, right? Probably more than that. So depending on what the duration was, the lag between the trip to Vegas and the development of symptoms and the positive HIV test, that might pique your interest. There's something else in the facts that's put there to make you think about the possibility that the source is not the prostitute.
Isn't the transmission rate
Huh?
isn't the transmission rate with the condom male, female?
But, yes, I mean, that you're surprised, right? He used condoms, it's not supposed to happen, but still could happen, right? Okay, well, that's important for a number of reasons, right? But presumably he was having unprotected sex with his wife before that, right? So what difference does it make in terms of her infecting him? How does the fact that he had unprotected sex with her after the trip increase that possibility?
We don't know what she was doing when he was in Vegas.
Okay, so yeah, when the cat's away, right? But there's something else. Yes, the unexpected child, the 8-year-old child, right? So unexpected to who, right? So maybe it increases the likelihood, let's say, of marital infidelity. Okay, so it's important that you think about the possibility. It's important that you think about the possibility that maybe his construction of the situation is not the actual situation. Okay? Okay, so we might have avoided it, okay? So what are we going to do? Are we going to breach confidentiality? We've already told him you got to tell her, right? And he's like, I'm not telling her, right? Now what do you do?
Does being her doctor complicate your duty to tell her?
What do you think?
It could, because you now know something.
Well, suppose you weren't her doctor.
Oh, well, I mean, it's still hard. I just thought that because you're
What's
both
the,
of their
so
doctors.
let's think about that question. Though. Suppose you weren't her doctor. What's the nature of the duty that you owe her? Huh? Well, she's an identifiable third party, but she's a third party, right? If she's not your patient, she's a third party. And so now we're talking about Tarasov, and we're talking about Bradshaw, and we're talking about Pate v. Threlkel and Safer v. Pack. We're talking about third parties.
So we're in Naples or we're in Florida.
Right.
So if we tell the patient,
Well, again,
discharged our.
Well, that was about a genetic case, okay, but you could argue that under what, Pate v. Threlkel, that if you tell the patient you discharged your duty, okay, unless there's some other law in effect that has superseded that, something that's directly on point, that's related to HIV.
Don't you have to tell the health department?
Yeah, they do.
You do have to tell the health
And
department.
won't they try and go find who he had sex with and tell them?
Yes, so there's a law, so that's good that you thought about your mandatory duty to report, and that there is a law that deals with HIV in Florida, and it's called the Florida Omnibus AIDS Act. Okay? And here's what it says, okay? So if you're not sure what to do and you don't know if there's any law that's on point, you could always call your lawyer and say, listen, this is the situation, where do I, is there any law that affects it? The Florida Omnibus AIDS Act says that there is no duty. There's no duty to warn third parties, but there's a privilege to warn. You are privileged to warn. You may warn. That privilege exists only when the patient discloses the identity of the partner who's at risk. And under that privilege to warn, the practitioner must adhere to the protocol prescribed by the Department of Health. There's a protocol, the hoops that you have to jump through if you're going to warn, the third party. If you release HIV information in an unauthorized fashion, they can come after your license. You can be sued for negligence and invasion of privacy. And apparently, it's also a criminal offense, first-degree misdemeanor, in some cases with up to a year of punishment, depending on the facts of the situation. It can be a third-degree felony with up to 5 years of imprisonment if it's done with malicious intent or for monetary gain. And you're going to have this case, I'm going to give you the slides, and it actually will have a link in there to the Florida Omnibus AIDS Act, and you can look at the text of the statute. I think that'll help you. So you're gonna tell the health department, and they're gonna then they'll be responsible for you. You must tell the health department. Okay, you must tell the health department, and then they're gonna do contact tracing. Okay. But you asked the question: does it matter that she's your patient or not? Now, if you look at the Florida Omnibus AIDS Act, it says that there's no duty to warn third parties. So, if she's not your patient, that would seem to protect you, right? It says there's no duty, there's a privilege to warn. Only thing is that if you warn, you got to tell the patient you're going to warn, and you got to ask them, what do you want me to do? Do you want to break the news? Do you want me to break the news? Do you want the health department to break the news? There's procedural hoops that you have to jump through. Okay? The question is, though, does that apply in this situation, where Deborah is your patient as well? Is that law going to protect you in a situation where Deborah is your patient? What do you think? You have a special relationship with her. Okay, so this is not a duty that you owe to a foreseeable third party or even identifiable third party. This is a fiduciary duty that you owe to your patient. Yeah.
Can you just advise her, hey, it's come to my attention that one of your sexual partners is HIV positive, and not tell her it's your husband?
Well, what do you think? Let's ask the ladies how they think that your doctor calls you in. How do you think? How would you greet that if your doctor called you into the office and said, one of your sexual partners, married lady, one of your sexual partners?
Even if you had more, old school, let's see, who else would you know that comes into that office, so.
Yeah.
Maybe you got a call from the health department because you're her doctor, and you can say, hey, I've been made aware of a partner of yours. They've identified you as a partner, that they had sex with you. Maybe she had unprotected sex with some other guy, so it could be the other guy that called the health department and then they told you.
So if she has multiple sexual partners,
Yeah, oh, it's a big if.
and if she's, then maybe. But if suppose she's monogamous, suppose she's been faithful.
Well, that's the husband's fault then. It's too bad for him. You're still not telling her who it is. She can.
But you still breached.
Yeah.
Right? You breached, and you can't tainted any other, it's still a breach.
But you have that duty to her, you said. Don't you have that special relationship with her that you have to warn?
Oh, you
her?
arguably have a duty, you have, if she's your, but, okay, but that's the thing. If you owe her a duty to tell her, then why would you say, then why not just say, you know, Richard's HIV positive? Why would you say
I
one
don't
of your
know.
partners,
I don't
one of your many partners is HIV positive?
No, I didn't say many.
Okay.
Just one. Somebody has identified you as a partner who's HIV positive, and that way you're not, technically breaking the confidentiality of Richard, but you're warning your patient that you have that special relationship.
I'm gonna post the materials for you, work through the case yourself, think about it, make sure you're familiar with the slides, okay? And if anybody has any questions about the case, then we can talk about it next time, but we're out of time, so I don't wanna.
Alright, this, you guys can all leave if you want. I was just wanting to go back to where the physicians may be liable for harm to third parties where the three conditions are met. And way back before we started talking about this HIV stuff, I was thinking kind of, I guess, early on, like, what if the physician has a patient, they're married, and they have a condition that could be contagious to their, you know, significant other, but the physician thinks, or, you know, has reason to believe that their patient has multiple other partners. So would informing the significant other, the spouse, be part of meeting that requirement?
Good
Or
question. One of the
do you
things-
need to try and find the other partner?
I'm not gonna answer that question.
Okay.
What I want you to do is when you read the materials, when you read the slides, ask yourself the question, based on what the slides tell you about that statute and the link to the statute. Look up the statute, see what it says, and ask yourself this question, okay? Suppose you tell Richard, you know, Richard, under the law, under Florida law, if you test positive, I need to disclose that, or I am privileged to disclose that to Deborah, okay? And in fact, I might have to disclose it to her because she's my patient, okay? And he says, I don't want to get tested.
That's what I was asking.
Now what do you do? See what the statute says. See what the statute says you should do. Now, it's easy in this case, right? It's relatively easy in this case because you didn't really think he was HIV positive, did you? This came as a shock, right? So maybe you think about what you would have to do under those circumstances. Then ask yourself this question. Suppose the story changed. Suppose the story was different. Suppose the story is, I went out to Las Vegas and I had unprotected sex with prostitutes. Well, how long have you been doing that? Well, I've been doing that for a long time. I like the risk, the thrill of the risk. He goes, and I especially like the IV drug abusing. Those are my favorite, because the risk is heightened. All right? Now the question is, now what do you do? Now the risk calculus has changed, right? So what should you do morally, and what does the statute say that you should do or can do? So look at it from those standpoints too. Okay?
Okay.
All right. We'll talk next time.